Alex here with the legal nuts and bolts video on affidavits and declarations. In this video, I'll cover the purpose behind an affidavit and, more importantly, their limitations. For anyone who doesn't know, an affidavit is basically a sworn notarized statement from a person that you attach to a motion or file in any kind of court proceeding. It's basically a list of statements, factual statements from that witness. If it's an expert witness, it could be like opinions and such, things like that, that are opinions that are related to what they're an expert in. The point I'm trying to make here is, for example, in a child custody case, you don't want somebody to put an affidavit together saying that the kids should live with you. That's a conclusion that the court's going to make. Instead, they're going to put facts in there. I've never seen this person abuse their kids. I've seen this person take their kids to school on time all the time. Anyway, these are really small potato things. Better examples would be like the affidavit I got from my son's dentist, which talked about how many crowns he needed, how many extractions he needed, when he got the surgery, was my ex there, things like that. The hygienist, how the red coat tests worked, which teeth showed up pink or purple, how many days that indicated that his teeth weren't being brushed. When I got the attendance lady's affidavit, how many absences happened, on what days did the absences happen. It's facts, facts, facts. The affidavit is going to be a person swearing to a bunch of facts that you can then say in your motion, here's what's going on, and here's this affidavit from this person swearing that these things happened. You know, it's not just me saying our son was absent. The attendance keeper is swearing under oath that our kid was absent. It's not just me saying that he lost, that he had 2 extractions and 5 crowns. The dentist is swearing under oath that he, had 5 crowns, 2 extractions. So the point of an affidavit is you back up your allegations in your motion or in your complaint with a statement of fact from other people who know these things. And as I mentioned, the more important people, professionals, teachers, dentists, principals, people like that are the best. In weird cases, I mentioned in a previous video, like my neighbor caught my ex peeking through the window while I was on vacation. I just got an affidavit of that just in case in the future I needed to use it, because I was thinking I might get another no contact order against her. So, I mean, what's it going to say in there? There was a crazy person? No. How's he going to know he's crazy? She's crazy? No. It's going to state a bunch of facts. On this date, at this time, I saw a person go to a window. This window is the address of Mr. Falcone. I approached this witness. I asked them what they were doing. They stated this. I stated this. So it's just a list of facts. It's not going to be something like, you should put this person in, she should be in big trouble for peeking in my neighbor's window. No, I mean, that's something that the court will decide. It's not a statement. It's not a fact. Anyway, I'm going to get to the next issue, which is the limitations on an affidavit, and then I'll go over declarations. So affidavits sound really powerful, and they definitely are powerful, and they definitely had an impact on my ex's attorney, because here I am, just a regular old person representing myself, and I'm getting all these people to swear all these things under oath. I was like 3 different teachers, as I mentioned, a hygienist, a dentist, a psychologist, lay witnesses. These people are all filing affidavits. So it alarms your opponent's attorney, if they have an attorney, because it's not just you saying all these things that are apparently lies or crazy things. It's all these other people who aren't even close to you. That's even better. It's not mom and dad and sister and brother. It's doctor this and doctor that and anyway, Mr. or Mrs. Teacher here. These obviously they're powerful. They add weight to your case, but affidavits stop at the motions. When you file your motions, when you file your motion and then your opponent opposes it, and then you file your reply, the court is going to consider that the motion, the opposition, the reply, the briefs. The court is going to consider that and decide whether or not you're going to get an evidentiary hearing. Once you have your evidentiary hearing or your trial, you can no longer rely on those affidavits. This is a mistake some people make. They'll think, oh, my papers were so good, I got affidavits, declarations, all these people are swearing things under oath. You go to court, and then your opponent's attorney says, you can't use those here. And they're right. You can only use those to show that you've built something known as a prima facie case. A prima facie case is a case where you appear to be entitled to the relief you're requesting. The court hasn't decided yet whether you actually are. The court has decided that it appears that you might be. And therefore, since it appears that you might be entitled, you're going to get your hearing. Well, now you need to actually get those witnesses in the courtroom. And I mentioned this in previous videos. There might be weird statutes in other states that will allow you to rely on statements, letters, and affidavits. Check into that, because if that's true, then you don't need the witness to come to court. And I covered this in a previous video. But in Nevada, in my child custody case, I know for a fact that if I would have gone to my motion to modify physical custody with those affidavits about all the things that happened to my son's teeth, I would have probably lost. My opponent's attorney, or she actually didn't have an, that was the one hearing she didn't have an attorney. She didn't have an attorney at that hearing, but if she did, and she may have even known how to do it, because even though she didn't have an attorney, there were some exhibits, there was some evidence that she got stricken. Next thing you know, you can't use those affidavits, and now you've lost your case. And it sucks. It's not really fair. I've mentioned in a previous video, some judges will be nice and try to get your ex to admit the things that were in your affidavit or your letter. I've seen this happen before. I've seen somebody bring something that's not admissible, like a police report, a letter from a teacher, and it's not admissible, but what the judge will do is they'll ask your opponent questions and see if they admit it. If they admit it, they can rely on your opponent's testimony, and that counts as the evidence they needed to rule in your favor. Some judges will do this. I call it being nice, because they don't have to do it. And really, only the nice ones try. But some judges won't. Some judges won't do it. They won't try, and they'll just say, you know what, this isn't good. You can't use this. And then your ex will think to themselves, whew, I'm safe. You know, whereas the other judge is going to be, he won't say anything. He'll be quiet about it, and then he'll ask your ex, did this happen? Did he have 5 crowns? Did he have 2 extractions? And then your opponent might be embarrassed and afraid to lie about something that you could eventually get proof on, and they'll say, yeah, that's true that happened. And then now it's okay. You brought an affidavit. It really wasn't the right thing to do. You needed the witness, but it doesn't matter because your opponent admitted to it in open court, and that counts as evidence. So sometimes that'll happen. I heard of situations where something really scary is going on, and somebody will not bring the witness, and the court will temporarily enter an order, and they'll say, you know, I want you to have temporary physical custody, and I'm going to set another hearing, and I want you to get that witness in the courtroom. Sometimes that'll happen. But most of the time, the judge will just deny it. They'll just deny your motion, and that's that. And they won't explain why, and you won't know what's going on, and it won't feel fair. My first judge was very much like that. The only time he ever really helped me was way in the beginning. When I stated that my ex had attempted suicide, and he helped me, and he said he wanted her to bring he wanted her attorney to bring her psychiatric records to court. But I didn't subpoena them. I didn't ask for, I didn't ask for them in discovery, so he could have said, you know what, you messed up, you didn't subpoena those records, now I can't consider them. He could have said that, but no, he helped me out. He was scared about what was going on, and he said, you know what, I want to see these things in here. But I've said in a previous video, don't rely on that. Don't rely on a nice judge, because you're just playing with dice. You're putting your kid's welfare into the hands of pure luck and the hands of fate. It's better to try and take control of your case and follow the rules and control your case. And believe it or not, I've mentioned before, the judges like that better, because they're doing so many cases at the same time. They don't always have all the time in the world to try and do everything for all these different people that are representing themselves. They forget things, they miss things, they're thinking about other cases. If you follow the rules and get the affidavits that you need, and put and make sure the witness comes to the court, to the evidentiary hearing. Once you get an evidentiary hearing, it's a lot easier on your judge, because then you're doing everything that you're supposed to be doing, and they can sort of just do their job, which is to judge, the testimony of the witnesses and consider the evidence, rather than trying to be your attorney, which, as I've mentioned, I wish I could remember the title. that video. I might put it down in the description below so that you can. I know I covered this issue about expecting your judge to know what's going on, to come into court, know what's going on, and have all these ideas and try to work with you. Really, they don't like to do that. It looks biased when they start helping one person and not the other. It looks unfair. So if they do decide to help you, it's going to be in this in sort of this give or take way where both people kind of leave with a little bit of something. And that's not always the best situation when you're in a case with like a personality disordered ex or like a severe abuser. In those types of cases, you need to win the cases. So with that, I'm going to cover declarations next. In Nevada, and this is probably similar in the other states, but I'm not sure where you can find it in the other states. In Nevada, it's Chapter 53, and it covers how you can get a declaration in lieu of an affidavit. And the purpose for it is to just basically make your job a little bit easier in that you can skip the whole step about getting a notary. So normally, you type up your affidavit, and when you get the person to sign it, they have to sign it in front of a notary. The notary will put their little stamp on it, charge like $5 or $10, sign it, put their name in a book, and get their ID. It looks great. I mean, it's very formal, but sometimes in really like low-key areas, people will just want to get a declaration instead of an affidavit. It's the same exact thing in Nevada, except that you have to follow a couple extra steps that are easier. So you don't need a notary. You don't have to get a whole third person involved. You don't have to get up, pay them money, get that stamp, and put your driver's license in their little book. All you got to do is call it a declaration at the top, and you put at the bottom very specific language as required in the statutes. I'm going to go ahead and cite the statute in the description below so you can take a look at what I'm talking about. Something like the undersigned hereby declares or swears under penalty of perjury that they, under the laws of the state of Nevada or something. I'm really paraphrasing. I'll put the statement down below. And those magic words will, I'm serious, that magic phrase, verbatim, word for word, if you put that in there, now you don't need a notary. Instead of an affidavit, you got a declaration, and it has the same power as an affidavit would have if you went and got it. As I mentioned, it just saves money and it saves time, and I use them all the time. I loved it because I wouldn't have to, getting an affidavit and a notary, it just takes a lot more time to coordinate, getting your witness or whoever to appear and sign that thing, and it just adds it's just a hassle. So take a look at how Nevada's Chapter 53 declaration in lieu of affidavit works, and look out for something similar in your state. I'm sure there's something in your state. I know there's something in the federal statutes that does the same thing. Look for that. Sometimes you can find it in your self-help packets. So a good trick is to go onto your court's like self-help website and like download some of their packets and look around. You'll find somewhere in those packets where they have that that little nifty declaration, and just basically steal that language. Anytime you want to write your own declaration, look for how it's supposed to look and kind of copy it. I mean, it's better to actually get the statute so you know what you're doing, but as a last resort, you can do that. Again, check the description below. I'll cite the statute in the chapter, and I'll have a link so that you can go and see what I'm talking about. As I mentioned, it's a declaration in lieu of affidavit. It's the same thing, just easier, cheaper, quicker, less of a hassle. Used them all the time, loved them. If you have any questions on affidavits and declarations, feel free to post a comment or send me an email. With that, I'll go ahead and end this video.